Hello again. Welcome back. I'm Professor John Blakeman from the UW-Stevens Point Political Science Department, and this is Lecture 9 of my ongoing lecture series on the U.S. Constitution, sponsored by the UW-Stevens Point Alumni Association and their Alumni College Experience. So in this case, we are again looking at congressional power, but we're finally getting out of the 1800s with Marbury versus Madison, McCulloch versus Maryland, Gibbons versus Ogden. Here we are in the 20th century, 1937, with a very famous case, NLRB versus Jones and Laughlin Steel. National Labor Relations Board versus Jones and Laughlin Steel. If you say that case name 3 times, you will fall asleep. Try it sometime. Okay, so this case. Can Congress use its Commerce Clause powers to regulate labor relations? Will the New Deal survive the Supreme Court? Will the Supreme Court survive Congress and the presidency? So there's a lot of stuff going on. So NLRB versus Jones and Laughlin Steel. The cases we've talked about so far over congressional power, McCulloch versus Maryland, Gibbons versus Ogden. Those are what we might call the classic view of congressional power. And that's where we, remember, have Chief Justice John Marshall of the Supreme Court, who's an avowed Federalist. He interprets the powers of Congress broadly, what we might call a nationalist interpretation, because Marshall, as a Federalist, wants to help create a strong national government with the power it needs to regulate a national economy. Marshall leaves the Supreme Court in 1835, and the court goes through several changes in justices, as it always does. By the late 1870s, the post-Civil War era, all the way to the New Deal, we're starting to see the Supreme Court change its interpretation of congressional power and Congress's power over the Commerce Clause and commerce among the states. And the court begins to narrow its view, its interpretation of the Commerce Clause. And it does so in a couple of ways. One, the Supreme Court says, well, there's a distinction between intrastate and interstate economic activity. So economic activity like manufacturing or producing something, like a rifle, a pistol, coal, steel, those are things that occur within the territory of a state, and they will generally be off limits to federal regulation. Economic activity that occurs from one state to another, interstate economic activity, something like distributing a manufactured good, transporting a manufactured good, those things can be regulated by the national government under Congress's Commerce Clause power. And so the distinction between intrastate and interstate economic activity, by the 1890s, it's becoming more standard in our interpretation of the Commerce Clause. And then the Supreme Court announces another approach as well. This sort of dovetails with the intrastate-interstate distinction, and that is Congress can regulate things that directly affect commerce among the states, but it cannot regulate activity that indirectly affects commerce. And this becomes what we call the direct-indirect distinction in the Commerce Clause. And so we have a couple of things going on. The Supreme Court overall is narrowing its interpretation of the Commerce Clause, narrowing its interpretation of congressional power. It's generally not allowing Congress to regulate economic activity that occurs within a single state only, intrastate economic activity. It does allow the national government to regulate economic activity from one state to another, but it doesn't allow the national government to regulate economic activity that only indirectly affects commerce. It will only allow the national government to regulate economic activity that directly affects or has an impact on commerce from one state to another. So yeah, this is all very, very confusing. Yeah, of course it is. And it turns out that lower federal judges by the 1910s and 1920s, are finding it very, very difficult, especially to apply this direct, indirect approach to interstate commerce. It's just not all that clear what kind of economic activity directly affects or interferes or impacts commerce, and what kind of economic activity indirectly affects commerce. You know, adjectives are important, okay? Adjectives and adverbs are important, but they often have to be interpreted and applied at the source. Now, along the way, the Supreme Court is also creating, or I shouldn't say creating, but interpreting the Constitution through what we call a laissez-faire lens. And the Supreme Court, a majority of justices by the early 1900s, view the Constitution in terms of laissez-faire economics, which basically means minimal government intervention in the economy overall. You know, we tack this onto the intrastate, interstate, indirect, direct effects doctrines in the Commerce Clause. And what we end up with by the early 1900s is a very restrictive view of national authority over economic activity, and also a restrictive view of state and local regulatory authority over economic activity. Very famous case, now overturned, is 1905 Laughlin versus the state of New York, where the Supreme Court announces that the Constitution contains an implied, unwritten right of an individual to contract his or her labor. That implied right to contract doctrine, we finally see it overturned by the early 1940s. Okay, so let's jump to the New Deal. And you know, you have a good understanding of the New Deal, the Great Depression, and so you know that by the early 1930s, Franklin Roosevelt is elected president in 1932, and he comes into the Oval Office with a campaign pledge to reform the American economy, to put in place the New Deal. And some of the basic elements of the New Deal rely on federal regulation of the economy, from labor relations to wages to pensions, Social Security, to national regulation of agriculture, the coal industry, so on and so forth. But Franklin Roosevelt's, FDR's New Deal program, even though it is supported by the American public and a majority of members of Congress, it runs into opposition at the Supreme Court. And so by 1935, the Supreme Court is striking down several New Deal statutes as unconstitutional, an unconstitutional use of Congress's Commerce Clause power. And the decisions are always very, very close, 5-4. And you have this block of justices called the Four Horsemen. Yep, the Four Horsemen of the Apocalypse. Justices Van Deventer, Sutherland, Butler, and McReynolds. Each of them is over 70, and we'll get to that point in a second. But they comprise the very conservative block of Supreme Court justices. They are very, very wedded to that laissez-faire interpretation of the Constitution, and they are always able to bring one other justice over to their side to form a majority to strike down the New Deal. So by 1936, 1937, the Supreme Court, Congress, and the executive branch are basically at loggerheads with each other. So, 1937, Franklin Roosevelt introduces his famous court packing plan. It's a bill introduced into Congress. And Roosevelt suggests for his bill that for every justice over 70 on the Supreme Court, a new justice will be added. He's not talking about taking away justices. Roosevelt is talking about expanding the size of the Supreme Court. Now, on the one hand, Congress has the authority to expand the Supreme Court, and Congress has exercised that authority over 200 years. So constitutionally, there's nothing wrong with Congress adding more justices to the Supreme Court. Politically, however, there will be significant problems here. And it turns out that a majority of members of Congress do not like FDR's plan to expand the size of the Supreme Court. They simply see it as the president trying to manipulate a co-equal branch of government because that branch is frustrating the president's policy agenda. And that's probably true. All right, FDR gives a very famous fireside chat to the nation, where he accuses older Supreme Court justices of blocking the will of the majority. And he says it's time to add more and younger justices to the Supreme Court. It just so happens there are also several New Deal cases pending at the Supreme Court at that time. Congress is ultimately unwilling to approve Roosevelt's plan. So it goes away. But Roosevelt has sent a very interesting message. Oh, and by the way, just in case you're wondering, you know, this political cartoon on the right of the screen is by Herb Bloch, the famous political cartoonist who drew a lot of cartoons for the Washington Post, sometimes for the New York Times. Sort of pokes fun at Roosevelt and his plan to expand the size of the Supreme Court. It was one of probably hundreds of political cartoons out there about this very issue. Let's get to the case, because we'll see that Roosevelt's court packing plan does affect, we suspect, the Supreme Court. So we've got NLRB versus Jones and Laughlin Steel, National Labor Relations Board versus Jones and Laughlin Steel. And the NLRB, still around, was created by the National Labor Relations Act, a New Deal statute, 1935. The NLRB's job is to investigate issues concerning labor unrest in the American economy. And the NLRB is supposed to protect the rights of workers to form unions. So Jones and Laughlin Steel, which is a highly integrated multi-state steel company. It has subsidiaries in the Minnesota Iron Range that mine iron ore. It has its own shipping on the Great Lakes that moves the iron ore to its ports in Pennsylvania. It has its own train system that moves the ore from iron mines in Minnesota to the port in Duluth, and then from the ports in Pennsylvania on down to its steel plants in Pittsburgh and Aliquippa. And so it's what we call a highly integrated multi-state enterprise. So Jones and Laughlin Steel, one of their steel plants has workers in it who are trying to form a union, and so Jones and Laughlin fires them. The NLRB investigates and orders the steel company to reinstate those workers. Jones and Laughlin Steel refuses and claims that the NLRB is unconstitutional and the whole National Labor Relations Act is unconstitutional. Now, according to Jones and Laughlin Steel, Congress has used its Commerce Clause powers to regulate labor relations, not commerce. So therefore, this is all in a nutshell, therefore the statute must be unconstitutional. The Supreme Court disagrees 5-4. 5 justices rule that the NLRB, or the National Labor Relations Act, is constitutional, and the NLRB has the authority under the statute to investigate labor relations and the breakdown of labor relations. The 4 horsemen dissent, as they would have, of course, but they were unable, as we can figure out, to bring one other justice to their side. This case is sometimes called the switch in time that saved 9. You know, the Supreme Court is under threat from the presidency. And by under threat, we don't mean the Supreme Court is going to be eradicated by the executive branch, but the executive branch, FDR, has made it quite clear that he will try to expand the size of the Supreme Court to get a favorable ruling. So the switch in time that saves 9. You know, the justices, their decision is favorable to the Roosevelt administration, and the idea of packing the court goes away. It probably would have failed in Congress to begin with. But what happens next? 1938, other New Deal cases are on their way, and the Supreme Court between 1938 and 1941 uphold some of the basic elements of the New Deal, many of which are still around today, like the Agricultural Adjustment Act, which contains our modern system of agricultural subsidies to farmers, the Fair Labor Standards Act, which concerns labor relations, the minimum wage, the Social Security Act was upheld, the Federal Child Labor Act was upheld, allowing the federal government to take steps to discourage the use of child labor in the American workforce. Between 1937 and 1939, 3 of the 4 horsemen retire, giving President Roosevelt 3 new appointments to the Supreme Court. So by 1940, the court is clearly a Roosevelt court. Okay, so let's take a look at the case. So just let me get the case up here. There we go. And so I've really edited this case down for you. And I did take out the dissenting opinion by the 4 horsemen. For some reason, anyway, it's reprinted in a separate part of the U.S. Reports volume. I'm not quite sure why. But if you really, really want to read it, you could certainly find it online. And the dissent does summarize how the 4 justices essentially viewed the Commerce Clause restricted. So this case is fairly straightforward, you know, and the majority starts by saying, well, you know, the facts of the case established by the National Labor Relations Board in its administrative hearing indicate that Jones and Laughlin Steel is a self-contained, highly integrated body. It is a huge multi-state corporation where it gets raw materials from the upper Midwest. It moves those raw materials on through the Great Lakes to Pennsylvania, where it puts them together in manufactured steel, which it then sells through its offices throughout the United States. So as the court puts it, relying on the NLRB's investigation, the entire steel industry, 33,000 men mine ore, 44,000 men mine coal, 4,000 men quarry limestone, 16,000 men manufacture coke, 343,000 men manufacture steel, and 83,000 men transport the product. About 10,000 employees at the Aliquippa plant, which was the focus of the labor unrest and the NLRB's investigation. We will come back to this point in a second, okay? But it's this idea of Jones and Laughlin Steel as a highly integrated multi-state corporation that really matters here. Now the court goes on to say, okay, let's take a look at what Congress means to do with its National Labor Relations Act and the creation of the National Labor Relations Board. And so Section 10 of the Act, just very briefly, the board is empowered, you know, and this is the statute that Congress wrote, passed, signed by the president. The board is empowered to prevent any person from engaging in any unfair labor practice affecting commerce. Now, this is really important. This is where Congress is using its commerce power to regulate labor relations and to allow the federal government to, excuse me, regulate unfair labor practices. And so if an unfair labor practice affects commerce, it can fall under federal regulation. And the court says down here, the term affecting commerce means, and here actually the court is quoting the statute. So these are the words of Congress. The term affecting commerce in the statute means commerce or burdening or obstructing commerce or the free flow of commerce or having led or tending to lead to a labor dispute, burdening or obstructing commerce or the free flow of commerce. Yeah, a lot of words there. But what Congress is saying is it is regulating economic activity, in this case, unfair labor practices, that burden or obstruct or interfere with the free flow of commerce from one state to another. In a sense, that's a highly specific factual question when you think about it. But the Supreme Court says in the statute, the definition of affecting commerce is one of exclusion as well as inclusion. Congress is granting authority to the NLRB, the Labor Relations Board. It is not extending power to the board to regulate all industrial employees and employers. It is not imposing collective bargaining on all of industry. It's only going to reach that that type of activity that burdens or obstructs commerce. All right. And the court says Congress has the authority to regulate things which directly burden or obstruct commerce or interfere with the free flow of commerce. It's the effect upon commerce, not the source of injury, which is the criteria. What the court is signaling to Congress, essentially, and to the rest of the nation, is when Congress wants to use its Commerce Clause power to regulate a type of activity that may burden or interfere with commerce from one state to another, it will be judged by the effect upon commerce itself, not the source of the injury. The source of the injury in this case is unfair labor practices. But the court says that's not what we're looking at. We're not looking at the source of the injury. We're looking at its effect, the injury's effect upon commerce. And that's how we judge whether Congress can regulate here or not. Okay, so moving towards the end of the opinion. So the court says the congressional authority to protect interstate commerce from burdens and obstructions is not limited to transactions which are part of the flow of interstate or foreign commerce. Burdens and obstructions, things that interfere with commerce, may be due to injurious action springing from other sources. The fundamental principle, as the majority put it, is that the power to regulate commerce is the power to enact all appropriate legislation for its protection and advancement. Sounds a lot like Chief Justice John Marshall in Gibbons versus Ogden, McCullough versus Maryland. That power is plenary, which means the power is complete and may be exerted to protect interstate commerce no matter what the source of the danger which threatens it. Now, what the court is building up to is simply this. The court is saying intrastate activities, economic activities that occur within one specific state, by reason of close and intimate relation to interstate commerce, may fall under federal control. So what the court has effectively done is it has started to erode that interstate, intrastate distinction that the justices had put in place between the late 1870s on into the early 1900s. That economic activity that occurs within a state, one state only. And in fact, we could construe that to mean non-economic activity too. Activity itself, conduct, that poses an intimate relation to interstate commerce. Now, how we decide what an intimate relation is, well, that's the big gray area. Nonetheless, conduct that is closely or intimately related to interstate commerce may fall under federal control. So the national government, based on the court's decision here, does have the Commerce Clause authority to regulate activity that occurs within one state only. So, at the very end, as the court puts it, When industries organize themselves on a national scale, making their relation to interstate commerce the dominant factor in their activities, how can it be maintained that their industrial labor relations are a forbidden field into which Congress may not enter? And so what comes out of the case is an expansive reading of the Commerce Clause, that Congress can regulate activity within one state, intrastate activity, if that activity or conduct is closely or intimately related to interstate commerce. That Congress may regulate things within one state that burden commerce, that obstruct commerce. And ultimately, to go back up in the court's opinion here for just a second, giving full weight to respondents' contention with respect to a break in the complete continuity of the stream of commerce by reason of respondents' manufacturing operation, the fact remains that the stoppage of those operations by industrial strife would have a most serious effect upon interstate commerce. That stream of commerce argument, we will encounter that in subsequent Commerce Clause cases too. It's the idea that a lot of economic activity within the United States falls within a stream of commerce. And that stream, think about it as Chief Justice Marshall's intercourse approach to commerce, the process of commerce. The stream of commerce is generally the same, if you want to think about it like that. And it means, if we think about Congress regulating a stream of commerce, instead of just certain economic activity from one state to another, then certainly Congress and the national government have a lot more authority to regulate a lot more economic and even non-economic activity. Now, much of the New Deal is still in effect. And certainly the modern federal government, as we now know it, with the range of federal agencies that regulate economic activity and even non-economic activity. A lot of federal regulation is premised on the Commerce Clause, from certainly labor relations to education, to health, to welfare, to Social Security. And so the NLRB versus Jones and Laughlin Steel case, it's not the only New Deal case where the Supreme Court does expand Congress's power. It's one of many, but it represents the Supreme Court's shift towards a much broader reading of congressional power over interstate commerce. Now, I always like to point out to my students that the federal government, as we now know it, maybe you like what it does, maybe you don't like what it does, but it was created by Congress, by our elected representatives. And the way, arguably, we control it is through that political process. Now, one final thing here. After NLRB versus Jones and Laughlin Steel, yeah, Roosevelt leaves the Supreme Court alone. Remember, he gets 3 relatively quick appointments to the Supreme Court anyway, as the 4 horsemen start to resign. And no president since Roosevelt has tried to pack the Supreme Court by increasing the number. Every president since George Washington has tried to influence the types of people who serve as Supreme Court justices. So, for instance, President George Washington, his 5 appointees to the Supreme Court were all Federalists. George Washington was a Federalist. Every president uses the Supreme Court, in a sense, to protect his ideological legacy. That's just part of American politics. But as Roosevelt went a step too far when he tried to manipulate the actual number of Supreme Court justices to get the policy result that he wanted. One final point here. From 1937 to 1992, the Supreme Court dealt with a lot of Commerce Clause cases where Congress was using its Commerce Clause authority to create a new agency to regulate a new area, policy area in the United States. And from 1937 to 1992, whenever a Commerce Clause came up to the Supreme Court always validated Congress's use of interstate commerce authority. By 1992, the Supreme Court is becoming a little more conservative, and it starts to rein in congressional authority based on federalism. That's a completely different story altogether, and we're not looking at any of those cases. But even since 1992, arguably the Supreme Court has still remained generally conservative, and most of the justices do support the New Deal reading of the Constitution that comes out of NLRB versus Jones and Laughlin Steel. And so this reading of the Interstate Commerce Clause is deeply ingrained in liberal, moderate, and conservative Supreme Court justices, and the legal community for that matter. You will certainly encounter more conservative legal scholars who disagree with it, more conservative federal judges who disagree with it, but it is deeply embedded in our understanding of the Constitution now. And so I don't see it changing anytime soon. All right, thank you. Now, the next lectures will focus on presidential power. And so hopefully you will find those interesting. Thank you again.